Hello, and welcome to Know Your Rights, a short video series from Nevada Legal Services. Today, I'm going to discuss how to seal an eviction court record in Nevada. Nevada Revised Statutes 40.2545 covers the grounds for seeking to seal an eviction record in Nevada. I will also briefly discuss setting aside evictions pursuant to Rule 60B. All of these links are also in the description box below. First, I will give a very brief introduction to summary eviction in Nevada. Please see our other YouTube videos for more information about the summary eviction process and how to contest a summary eviction. In Nevada, if a tenant wants to contest an eviction, the tenant must initiate the court action. The landlord starts the eviction process by serving an eviction notice on the tenant. This notice does not have to be filed in a court first to be valid. The notice just has to contain all of the required information and be served on the tenant personally or by posting and mailing. If the tenant wants to contest the eviction, then the tenant must file a tenant's affidavit raising a legal defense within the required time period, 7 days for a rent notice or 5 days for other notices. If a tenant does not file the tenant's affidavit before the notice expires, the landlord can simply ask the court for a lockout order. This lockout order will then be posted on the door and give the tenant 24 hours to vacate. Once the tenant files the tenant's affidavit, an eviction case court file is created. If the tenant does not file the tenant's affidavit and the landlord gets the lockout order, this also creates an eviction case court file for the eviction order. The eviction case court file is a public record. NRS 40.2545 now seals eviction records, in some cases automatically, and in others after a request by the tenant. Pursuant to NRS 40.2545, the grounds to seal an eviction record can either be automatic or discretionary. Eviction records are automatically sealed in cases where the eviction is dismissed or where the tenant prevails at the eviction hearing. Then it is automatically sealed after the 10-day appeal timeframe has run. If the tenant files a tenant's affidavit, the eviction is automatically sealed after 31 days if the landlord does not file its complaint with the court. Finally, eviction notices themselves, without a court filing, are not subject to public inspection and should not be made a public record. In other cases, the tenant must ask the court to seal the eviction record. The tenant can try to first get the landlord to agree to seal the eviction and file a stipulation with the court. But more likely, the tenant will have to file a motion to ask the court to seal the eviction. A court can seal an eviction where the eviction should be set aside pursuant to Rule 60, more on that later, or if the interest of justice is not outweighed by the public's interest in accessing court records. The factors a court will consider include circumstances beyond the control of the tenant, other extenuating circumstances that led to the eviction, and the amount of time that has passed. So it might be more difficult to seal recent evictions. In your motion to seal, you want to explain any circumstances beyond your control that led to the eviction or other extenuating circumstances. Include concrete details of what led to the eviction. Provide any stories of redemption, how you've turned your life around since the eviction. Include the harmful effects of having the eviction record, that your rental applications have been rejected, your current housing circumstances, and explain why you need the record sealed. The motion must be filed in the eviction case, so use the same case number. Remember to always take copies along with you when you file so that you can keep a copy for yourself and serve a copy on the other party. Remember, the motion must be served on your landlord by mail. Make sure to have accurate contact information on the motion. Some courts will mail you hearing notices, some courts will only call you on the phone, and if you e-file, you will have to provide an email address for service of important court documents. Your landlord does have time to respond to the motion, generally 10 days. If you do not get a response from the landlord in that time frame, you will want to submit the proposed order to the court. You can also just do this when you file the motion if you e-file it, or provide copies of the proposed order when you file the motion. One of the other ways a tenant can request to seal an eviction record is to seek to have it set aside under Rule 60B. You can seek to set aside an eviction record the landlord received by default, meaning you did not attend the hearing or file the tenant's affidavit, where you have a good reason for failing to contest the eviction and you have a legal defense to the eviction. The factors that a court will consider are that you are filing this motion as soon as you realize you had the eviction on your record, you do not intend to delay any court proceedings by filing the motion, you do not understand the procedural requirements, and you have good faith. In most cases, the motion must be filed within 6 months of the eviction. A sample motion for both sealing and setting aside an eviction can be found on our website at nlslaw.net. If the court orders the eviction sealed, you need to mail the order to your former landlord and keep proof of the mailing. Remember, once the court seals the eviction, you will no longer have access to the court file. You may want to request a certified copy of the order to keep for yourself. Then dispute the eviction record with the tenant screening or credit reporting agencies if your eviction has already been reported. Otherwise, you are now legally allowed to say on a rental application that the sealed eviction never occurred. Please note, this does not mean that your landlord cannot report that you owed money or other negative information to a prospective landlord. The eviction case is just no longer a public record and should not be disclosed. This concludes this video on sealing eviction records. For more information about your rights and the forms discussed, you may contact any of our local offices or visit our website at nlslaw.net.